Hi there. Today I want to tell you about a recent decision from the Supreme Court of Canada that absolutely destroyed one of Justin Trudeau's marquee laws, the Impact Assessment Act. This was a reference from Alberta, and in this case, the Supreme Court found that this law, which is often referred to as the No More Pipelines Law, is unconstitutional. I can't wait to tell you all about it. If you're new here, welcome. My name is Christine, and I'm the litigation director for the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember nothing in my videos is ever legal advice. If you have your own legal question or problem, consult your own lawyer. So Canada's highest court, the Supreme Court, dealt a serious blow to the Trudeau government with a ruling on October 13th in a reference case that found that the Federal Impact Assessment Act is unconstitutional. This is a complex piece of legislation that was introduced in 2019 and was quickly given the nickname the No More Pipelines Law by opponents. This is because under the Impact Assessment Act, it is highly unlikely that any new pipelines will be approved or built in Canada. Now, it's important to know that the effects of the Impact Assessment Act are not limited to pipelines. Under the Impact Assessment Act, the federal government reviews all kinds of projects, including projects that are entirely within the borders of a single province, like mines, oil projects, or hydroelectric plants. Now, Alberta objected to this legislation, and they argued successfully at the Supreme Court that the federal government was regulating in areas of provincial jurisdiction. Now, the constitutionally controversial portions of the Impact Assessment Act related to something that's called designated projects. Now, designated projects under the Impact Assessment Act are subject to a statutory prohibition on any activities that may cause effects within federal jurisdiction. And absent federal approval, they are subject to a prohibition. So how do projects end up on that designated project list? Well, that is part of the problem. The list is set by regulation, but the Minister of the Environment also has far-ranging authority to unilaterally decide that a project will be subject to the Impact Assessment Act because, in his or her opinion, it may cause effects within federal jurisdiction. And once placed on that designated project list, projects are subject to a lengthy, years-long federal assessment on an exceedingly wide range of economic, social, health, environmental, and even gender-related impacts. The Impact Assessment Act essentially gave the federal government a veto power over natural resource projects, including projects that are entirely within a single province, if that project so much as glanced toward federal jurisdiction. For example, most natural resource projects are going to have some effect on greenhouse gas emissions, which, even if small, can cross provincial boundaries. And this, under the Impact Assessment Act, might be enough to put a project on the designated project list, and then have the federal government stop that project from taking place at all. Now, in a 5-2 decision from the Supreme Court, the offending provisions of the Act were declared unconstitutional. The designated projects portion of the Act was found to be what we call ultra vires, which is outside of the scope of the federal parliament, and therefore unconstitutional. And the majority of the court found that the Impact Assessment Act is not directed at regulating effects within federal jurisdictions as defined in that legislation, because the effects don't drive the scheme's decision-making functions. And the court also held that the defined term, effects within federal jurisdiction, doesn't align with the federal legislative jurisdiction. So the overbreadth of these effects exacerbates the constitutional frailties of the scheme's decision-making functions. The federal government had claimed that they could regulate so broadly on the basis of a few different sections of the Constitution Act 1867 that give them power to regulate certain things. The seacoast and inland fisheries, Indians and land reserved for Indians, that's a provision in the Constitution Act, as well as the provision of the Constitution Act that gives federal government the authority to regulate for the peace, order, and good government of Canada. And this is referred to as the POG Power. And it was under the POG Power that you may recall that the Supreme Court found the federal government had authority to create these national minimum standards for carbon pricing in Canada in a case reference called the Greenhouse Gas Pollution Pricing Act case. And that's also sometimes referred to as the carbon tax case. The Impact Assessment Act reference is really significant, and it could have the effect of stemming some of that bleeding of the provincial jurisdiction that was caused by that earlier carbon tax case from this same court. They may be attempting to maybe rein things in a little. Now, it's worth noting that the Supreme Court holding in the Impact Assessment Act reference is technically a holding that the legislation is unconstitutional in part. There were other provisions that the Supreme Court didn't find unconstitutional. They said that these provisions are not a problem. Namely, the federal government does have the authority to regulate projects on wholly owned federal land or projects outside of Canada. But I've seen some comments on Twitter from so-called experts saying this was only a partial unconstitutionality. Alberta didn't really win this case. Don't let these so-called experts fool you. This is a resounding victory for Alberta and for provincial rights. The regulation of projects on federally owned land or even outside the country itself was never what concerned Alberta. What concerned Alberta was the federal government's intrusion into their jurisdiction and telling Alberta that they could not develop their own projects. And the federal prohibition on provinces like Alberta, like Saskatchewan, developing the bounty of their own natural resources. That is what drew ire. I also think that the court's ability to do this, to have a partial finding of unconstitutionality, is because they severed the legislation and found that the key parts were unconstitutional. And I think that this finding of the ability to sever the legislation was a result of our intervention in this case. We were granted intervenor status at the Supreme Court, and we were the only party that made submissions on severance. And as a result of these arguments, the court found that this narrow secondary scheme that related to the regulation of federal projects or projects outside of Canada could be severed from the unconstitutional remainder of the act. And I think that our arguments at the Supreme Court were key in allowing the Supreme Court to actually be able to do that. So the question now is, what will the federal government do next? In response to the decision from the Supreme Court on Friday, the Natural Minister Resources, Jonathan Wilkinson, said that he sees the need for only small changes to the law. He said the concerns raised by the Supreme Court can be dealt with in a relatively surgical way. Now, this is really curious to me. The portions of the Impact Assessment Act that were declared to be incompatible with Canada's supreme law, the Constitution, those portions are core to the function of the Act itself. To address the court's reasoning, the government will need to make significant legislative amendments. If the response is going to be surgical in nature, as the minister claims, it is surgery on a fatally wounded patient. Now, the government no doubt wants to ensure that the projects it had previously stopped or indefinitely stalled will remain indefinitely stalled or stopped, but it's unclear how they will actually be able to achieve that. It's also important to acknowledge that while this case has been portrayed as a fight between environmental protection versus resource development, there's actually another really important principle at stake here, and that's federalism. The failure to adhere to Canada's constitutional division of powers promotes regulatory duplication and inconsistency. In turn, this leads to an unwieldy patchwork of legislation that can adversely impact things like capital investment, resource development, and economic prosperity across the entire country. The Fathers of Confederation made a deliberate choice to strike a delicate balance between centralization of power and regional diversity. And at its core, this decision in the Impact Assessment Act is a dispute about the contours of Canadian federalism, which has real-world practical implications for political and economic life in Canada. Now, as Chief Justice Wagner wrote in this case, He said, environmental protection remains one of today's most pressing challenges, and to meet this challenge, Parliament has the power to enact a scheme of environmental assessment. Parliament also has a duty, however, to act within the enduring division of powers framework laid out in our Constitution. I agree. Let me know what you think about this decision and what it might mean for Canada's economic future and political future. What kind of legislative changes do you think the federal Liberals are going to propose? And how exactly are they going to be surgical in nature? Leave a comment below and let me know what you think. If you want to keep up to date about all of our cases like this one, you can subscribe to our email freedom updates at theccf.ca/freedom updates. Thanks for watching, and let's keep fighting for freedom in Canada.